Communicate unless they were thinking we are here in a party or something.
I had tried to communicate. Issues happened. I've come at 5 or 5. Right? Asking, send me to just hold on or ask for a bit of time. They also not say. You can't give exact time.
Then tell them about our stand. You've been telling us about their stand. Tell them about ours. If it's not ready, tell them you can always come tomorrow.
The judgment is
What the judgment we said on email.
Yeah, the change on the e-filing portal.
it's ready and printed.
Good afternoon, all.
Good afternoon, everyone. Welcome to the Supreme Court. Ladies and gentlemen, welcome to the meeting. Honorable Judge Council, Honorable Mahmoud, the matter is the item petition number 269 of 2005, February morning, and vote this morning for the National Assembly and 9 others.
Just a moment, Council. A moment. Now, first and foremost, on behalf of the bench, I wish to profusely apologize for keeping you waiting from 2 p.m. when we were supposed to deliver this judgment. We had some challenges, equipment challenges, but we have overcome, and here we are. Are we ready to take the judgment at this hour, or we have it tomorrow at 2 p.m.? Thank you very much. Thank you. Do you accept our apologies?
Yes, we do.
On behalf of the rest?
We do. Yes, I do that on behalf of everybody.
Council, you are looking at me like you are not sure. Yes, you yourself. Yes.
No. My lady, we accept that.
Thank you very much. Truly appreciate your patience.
Is it program?
Yes, yes, please. Do.
On behalf of the petitioner, Senior Counsel for Unity is not here. Ogada, Aken Duwod, and Victor Ogeto. That is for the petition. I don't know whether they. Sorry, no, really. Forgetting that that's him, which will be the main party here. Then for the respondents, we have Mr. Emmanuel Vita for the first respondent, Moses Kipkogei for the second respondent, Josephat Kioni for the third respondent, and on behalf of the interested party, I appear and Jotham Marwa, together with Issa Mansour and Noor Hassan for the first interested party, Ali Ahmed, Ramadan Abubakar for the second interested party, Alakonya, Mwanga and Omenta for the third interested party, Mugisha and Mr. Mugisha and Mr. Rotich are for the fourth interested party. And we have appearing for the fifth interested party. And my friend Mr. Kro and Mr. Nyanode present for the sixth interest, for the seventh interested party, and Justice Mutunga, the eighth interested party. Thank you.
Thank you very much, Council, for the quorum. We do appreciate, and we have the quorum already typed, so we are not recording anything. So we have had constitutional petition number E of the selection and appointment of commissioners of the Independent Electoral and Boundaries Commission, IEBC, between Calvin Roy Omondi, Boniface Mwangi versus Attorney General, the Head of Public Service, the National Assembly, and interested parties who are Erastus Edum Fekon, Anne Jerin Derito, Moses Altalala Mokwana, Mary Karen Sorobit, Hassan Nur Hassan, Francis Odhiambo Adwal, Fahima Arafat Abdallah, and Justice Mutunga Mutuku. We will read this judgment in turns, and I'll be the first one to commence. By way of introduction, we have a short quote, and we say, "Those who cannot remember the past are condemned to repeat it." That statement was made 120 years ago by none other than George Santayana in his writings, Reason in Common Sense. The tragic events that followed the announcement of the presidential election results on 30th of December the year 2007 left an indelible scar on the conscience of our nation. The violence that followed thereafter engulfed large swaths of the Republic, and the upheaval was marked by loss of life, displacement of thousands of people, and the breakdown of public order. Those most unfortunate events were precipitated largely by the perception and allegations that the Electoral Commission of Kenya, ECK then, and its chairperson and commissioners had failed in their solemn duty to conduct free, fair, credible, and transparent elections. The social, economic, and institutional trauma that followed laid bare the dangers of electoral mismanagement and the fragile nature of public trust in democratic institutions. We therefore begin this judgment by venturing back to one of the most darkest chapters in the history of Kenya, because the historical viewpoint provides the context within which the former electoral body was dissolved and a new electoral management body reimagined under the Constitution of Kenya 2010 as the Independent Electoral and Boundaries Commission. There is perhaps no more of a Herculean task or an onerous role within Kenya's public life than serving as the chairperson or commissioner of the IEBC. Serving in the IEBC is not just another mundane ceremonial or administrative role. It is a solemn and weighty constitutional trust that calls upon members of the IEBC to safeguard the most sacred expression of the people's sovereignty, which is the vote. Persons who serve within the IEBC must therefore at all times be guided by the memory of that tragic period in our history, and they must commit themselves to embodying the commitment made by the people of Kenya that we shall never, and we emphasize, and in bold, we shall never as a nation return to those dark days because of an electoral management body. The IEBC occupies a unique and constitutionally entrenched role in the sentence of democratic governance in Kenya, established under Article 88 of the Constitution. The Commission is mandated to continuously register citizens as voters, regularly revise voters' register, delimit constituencies and wards, regulate the process by which parties nominate candidates for elections, settle electoral disputes, including those disputes arising from party primaries, nominations, register candidates for election, carry out voter education, facilitate election observation and monitoring, regulate campaign financing, develop and enforce a code of conduct for parties and candidates in respect of any election, monitor compliance with legislation relating to elections, delimit electoral units, conduct and supervise referenda and elections to any elective body or office established by the Constitution, and to ensure that such elections are free, fair, transparent, and credible. Article 88, upon establishing the Commission, proceeds to provide for appointment of the members of the Commission and commences with prohibitions of persons who are not eligible for appointment as members of the Commission in the following sub-article 2. From the Commission's constitutional mandate reproduced above, which is not exhaustive, the IEBC is a constitutional commission whose existence and functionality go to the very heart of representative democracy. In a constitutional order founded on the sovereignty of the people and the rule of law, the integrity of the electoral process is indispensable and non-negotiable. It is through elections that the sovereign will of the people of Kenya is periodically expressed and government authority legitimately renewed. The IEBC is therefore the primary guarantor of this foundational process. The Constitution envisages and demands an electoral body that is independent, neutral, efficient, and accountable, as understood and underscored in Articles 81 and 86. These provisions are not aspirational, they are immediate and imperative. The IEBC is under constitutional and legal obligation to operate at all times, free from political or partisan control, and to serve all Kenyans with impartiality and courage. Its independence is not meant to exist only on paper. It must be real and unimpeachable. The IEBC's independence is a safeguard for democracy, rule of law, electoral integrity, public confidence, and political stability of this country. The history of electoral disputes in Kenya, particularly the events surrounding the 2007 and 2017 general elections, underscore the far-reaching consequences of public mistrust in the electoral process. As highlighted in the Kriegler report and later reinforced by the Supreme Court's annulment of the initial 2017 presidential election results, institutional failures or perceived partiality of the IEBC can precipitate a constitutional crisis, civil unrest, and the erosion of state legitimacy. As the institutional embodiment of the people's democratic right to choose their leaders in a free and fair contest, the IEBC's competence, independence, and preparedness directly influence electoral legitimacy, peaceful transitions of power, and the realization of constitutional values such as equality, transparency, accountability, and inclusivity. It's now a well-settled principle of democratic governance that elections are not a one-day event. They are structured and they are continuous. They are a process. This process is governed by the Constitution, electoral laws, and the values of accountability and legitimacy. This understanding was strongly underscored in the report of the Independent Review Commission and the general elections held in Kenya on 27th of December 2007. That is the IREC report, famously known as the Kriegler report, which report warned against treating elections as an isolated occurrence. The Kriegler report emphasized that elections are a process, not an event, and that the credibility of an election begins with the construction or constitution of a credible electoral management body. The petition before us squarely revolves around the question of credibility of the IEBC that is proposed to be constituted. Drawing from the lessons of the past, it is beyond dispute that the timely establishment, adequate resourcing, and operational autonomy of the IEBC are matters of urgent constitutional priority for this nation. As recommended by the Kriegler Commission and as echoed in the country's subsequent reform initiatives and proposals, a fully constituted IEBC, which is also fully operational, should be in place at least 2 years prior to the general elections. This allows for proper planning in terms of delimitation of boundaries, voter registration and education, procurement of electoral materials, recruitment and training of staff, and resolution of pre-election disputes, among other critical functions and milestones as stated above in this judgment. So as we close this introductory part of this judgment, we would be remiss not to mention that it's deeply concerning that for nearly 2 years since the expiry of the terms of the former chairperson and commissioners, the commission has operated without a chairperson and commissioners. This gap has meant that the IEBC has been unable to conduct some of its very critical activities, including the holding of by-elections after the deaths or resignations of some of the elected members of the national and county legislatures. To neglect or delay proper constitution of the IEBC is not a procedural lapse. It is a direct affront to the constitutional order and a potential catalyst for electoral illegitimacy and political uncertainty. In light of the exceptional nature and urgency of the issues presented in this petition, and pursuant to the directions of the Honorable the Chief Justice and President of the Supreme Court of Kenya, this bench, in recognition of the importance of this matter, set aside other judicial commitments, though not completely, and had to undertake this onerous task of hearing and determining this petition within an expedited timeline. Accordingly, this bench had, and today we are rendering the decision in this petition within a period of 17 days from the date that we had this petition. That was on 23rd day of June, the year 2025, and in full fidelity to constitutional imperative for prompt and efficient resolution of disputes touching on matters of high public interest and therefore importance. This petition invites the court to reflect upon a foundational principle in the architecture of our democratic governance, which is the right of the citizens of Kenya to participate in free, fair, transparent, and credible elections administered by an independent, impartial, and competent electoral body. the social contractual relationship between the people of Kenya and the state will be a dead letter unless we have a credible IEBC. The issues raised before this court are not only of legal concern, but of deep constitutional, historical, and public significance, touching on the very legitimacy of the electoral process in the Republic of Kenya. That is our introduction of the petition. Reasons being, we have given that historical background which we believe and hope that those will have the opportunity to serve in that very important commission are taking notes. I will therefore give an introduction on the pleadings and we go to the decisional part. Will that be okay?
That's okay.
Thank you very much. Now, the petition is dated 13th day of May 2025 and is brought pursuant to the provisions of Articles 22 and 258 of the Constitution. It is supported by the affidavit sworn by Kelvin Roy Omondi, the first petitioner, on 13th May 2025. The rest contains the description of who those petitioners are, and it also describes who the respondents are and the interested parties. That is the initial interested parties, who were 7. We had an added 8th interested party. We then have the prayers which are sought in the petition, and so I will just highlight those prayers before we go to the decisional part. The petitioners are aggrieved by the manner in which the 1st to the 7th interested parties were selected and nominated to serve as chairperson and commissioners of the Independent Electoral and Boundaries Commission. They contend that the process of selection and nomination of the 1st to 7th interested parties was unconstitutional. Specifically, they make the following allegations. 1, that the nominations contravene the Constitution in that they were individually and collectively not representative of Kenya's diverse communities. 2, that no person with disabilities was nominated. 3, that the names were selected without any such prior consultation by the President with the majority and minority leadership of the National Assembly, contrary to the National Dialogue Committee report, NADCO. 4, that some of the nominees are constitutionally barred from selection, nomination, and appointment to the IEBC by virtue of having candidates for election within the constitutionally disallowed time frame, by virtue of having held high office within a political party within the constitutionally disallowed time frame, or by virtue of holding state or public office. 5, that some of the nominations were not merited as the particular nominees received low scores at the interviews. 6, that some of the nominations are tainted with bias or the perception of bias. 7, that the selection and nomination process lacked the requisite standards of public participation, transparency, and accountability. And lastly, that the selection and nomination process were procedurally flawed as typified by the issuance of a second and expanded shortlist of candidates. The petitioners therefore contend that the selections made by the IEBC selection panel were not based on merit, as some of the candidates did not achieve high scores in the interviews. Secondly, that the petitioners, that one Hassan Nur Hassan, the 5th interested party, was never shortlisted for the interviews and was only snuck in through an addendum contrary to the selection and nomination process under the IEBC Act. Further, the petitioners also claim that the nomination of Ms. Mary Karen Sorobit, the fourth interested party, is unconstitutional and unlawful, as she was, at the time of her nomination, a member of and office bearer of a political party, specifically having served as county chairperson of the Jubilee Party within the preceding 5 years of elections which were held in August the year 2022. This, according to the petitioners, contravenes the express provisions of Article 88, Sub-Article 2A of the Constitution, which prohibits the appointment of any person who has, within the preceding 5 years, held office in a political party. The petitioners aver that the nomination of Ms. Sorobit violates Article 10, which imposes upon all state organs and public officers the duty to uphold national values and principles of governance, including integrity, transparency, and accountability. The said nomination is said to also offend Article 73, 2A of the Constitution, which provides that the guiding principles of leadership and integrity include selection based on personal integrity, competence, and suitability. The petitioners argue that recent political affiliation of Ms. Sorobit undermines public confidence in the independence, neutrality, and impartiality required of members of the IEBC. Lastly, that the process leading to the nomination of Ms. Sorobit does not meet the threshold of a fair, open, and merit-based process as contemplated under Article 232, 1G of the Constitution, which requires transparency, timely, accurate provision of information to the public in matters of public service appointments. The petitioners are further aggrieved by the nomination of a proposed chairperson and a proposed commissioner, both said to hail from the Rift Valley. The petitioners say that this contravenes Articles 10, 232, and 250, Sub-Articles 3 and 4 of the Constitution, on account that the Constitution did not anticipate what they term as composition of the IEBC that would be dominated by a majority of persons from the same region, while excluding other regions of the Republic of Kenya. The petitioners therefore lament that the nomination list is unconstitutional and illegal, as it failed to include any person with disability, despite one having been selected by the panel and forwarded to the President for consideration. The selection panel is further accused of acting illegally and unconstitutionally, contrary to Article 88, Sub-Article 2 of the Constitution. And we have listed that. We find this important just to read out. As against Ms. Anne Jerry Nderitu, the second interested party, the allegation is that she is currently the registrar of political parties, and that therefore she is a state officer who is ineligible for appointment under Section 88, subsection 2B. We have said about Ms. Mary Karen Sorobit, that she was affiliated to Jubilee Party as the county chairperson. In addition, there are allegations that she was the executive director and member of the governing body. There was also an allegation that she was the deputy executive director, and that according to the constitution of the Jubilee Party, an executive director or their deputy are members of the party's governing body. As the fifth interested party, the petitioners say that this person is ineligible because, one, he contested and vied for the office of Governor of Mandera County in the 2017 and 2022 elections and affiliations with one Josephat Nanok, who is the State House Deputy Chief of Staff of the President, Office of the President, which allegedly arise from the first interested parties having served as the county attorney for Turkana County government under the leadership of Mr. Joseph Nanok, and that therefore his nomination is tainted partially with partiality and lack of neutrality, contrary to what is required as a chairperson of the commission. Additionally, the petitioners fault the selection and nomination of the first to the seventh interested parties globally, stating that the nomination was illegal and contrary to Articles 10, 27(1) of the Constitution on the requirement for public engagement, participation and consultation, as the President is said to have failed to engage or consult with the leaders of majority and minority political parties of the National Assembly prior to making those nominations as recommended by the National Dialogue Committee, the NADCO. According to the petitioners, the failure of the President and the selection panel to publicize the information relating to the performance of the candidates and to publish the IEBC selection panel's report on the interviews also offended Article 35 of the Constitution on access to information. The petitioners aver that the subsequent failure by the selection panel to avail the information pertaining to those interviews as requested by the petitioners was a second violation of Article 35 of the Constitution. They therefore pray as follows. These are the reliefs which now the petitioners seek from this court, and after we have read out the reliefs, we will not go into the opposition by the respondents and interested parties, as we have captured that very elaborately in this judgment. I'll therefore ask my brother, Justice Chigiti SC, to read out the reliefs verbatim. Welcome.
The petitioner seeks the following reliefs. A declaration does issue to the effect that the nomination and selection of Erastus Edung Ethekon and Angerin Derito, Moses Alutalala Mukwana, Mary Karen Sorobit, Hassan Nur Hassan, Francis Odhiambo Aduo, Fatima Arafat Abdallah is illegal, null and void, and 232 and 253. A declaration that the recommendation of Ms. Mary Karen Sorobit for appointment as a member of the Independent Electoral Boundaries Commission, IEBC, is unconstitutional, unlawful, and invalid for a reason that she was at the time of her nomination a member and office bearer of the Jubilee Party, contrary to Article 88(2)(a) of the Constitution of Kenya 2010, and is thereby conflicted and incapable of discharging her duties with impartiality, independence, and integrity required of a commissioner under Article 10, 73, 232 of the Constitution. D. a declaration that the recommendation of Ms. Anne Njerin Dirito for appointment as a member of the IEBC is unconstitutional, unlawful, and invalid for reason that she was, at the time of her nomination, a state officer contrary to Article 88(2)(b) of the Constitution of Kenya 2010, and is therefore conflicted and incapable of discharging her duties with the impartiality, independence, and integrity required of a commissioner under Articles 10, 73, and 232 of the Constitution. E. An order of certiorari be and is hereby issued to quash the decision and or recommendation of the selection panel for the appointment of commissioners to the IEBC to nominate Ms. Mary Karen Sorobit for appointment to the said commission. F. A declaration that the nomination of Erastus Edung Ethekon, Anne Njerin Dirito, Moses Alutalala Mukwana, Mary Karen Sorobit, Hassan Noor Hassan, Francis Odhiambo Aduol, Fahima Arafat Abdallah for appointment to the Independent Electoral and Boundaries Commission by the selection panel is unconstitutional, unlawful, null, and void for having been undertaken in a process that failed to comply with requirements of Articles 10, 73(2)(a), 88(2)(a), and 232(1)(g) and h, and 253 and 4 of the Constitution of Kenya. G. Pursuant to Article 23(3) of the Constitution of Kenya 2010, an order of certiorari does issue quashing the decision dated 8 May 2025, issued by the head of the public service to the effect of nominating Erastus Edung Ethekon, Anne Njerin Dirito, Moses Alutalala Mukwana, Mary Karen Sorobit, Hassan Noor Hassan, Francis Odhiambo Aduol, and Fahima Arafat Abdallah as members of the Independent Electoral and Boundaries Commission. H. An order of permanent injunction restraining Erastus Edung Ethekon, Anne Njerin Dirito, Moses Alutalala Mukwana, Mary Karen Sorobit, Hassan Noor Hassan, Francis Odhiambo Aduol, and Fahima Arafat Abdallah, nominated and or recommended by the selection panel for appointment as commissioners of the Independent Electoral Boundaries Commission from assuming, occupying, or performing the functions of the office of the IEBC on grounds of violation of the Constitution, including but not limited to breach of the principles of political neutrality, integrity, and fair administrative action as enshrined under Article 10, 73, 88(2)(a), 232, 253, and 4 of the Constitution of Kenya. I. A declaration that the Attorney General failed in their constitutional mandate under Article 1564 of the Constitution of Kenya 2010 by neglecting to provide independent, impartial, and sound legal advice to the executive regarding the nomination of Erastus Edung Ethekon, Anne Njerin Dirito, Moses Alutalala Mukwana, Mary Karen Sorobit, Hassan Noor Hassan, Francis Odhiambo Aduol, and Fahima Arafat Abdallah, commissioners of the IEBC, thereby failing to protect the rule of law and the public interest as mandated by the Constitution. Finally, J, any other or further orders, writs, and directions this court considers appropriate and just to grant for the purpose of the enforcement of the petitioner's fundamental rights and freedoms. Those are the reliefs as sought.